60 seconds, and then we'll go. Whenever you're ready.
Let me speak from this podium here. Let me just, on behalf of President Barbara Snyder, let me welcome everybody. I'm Bud Bazelak, the provost, to this event this afternoon, the annual Constitution Day Forum. It's great to be here. This is an event I've actually been involved in a couple other times in the past, and it always leads to some very interesting conversation, discussion around very complex issues certainly related to the Constitution. I want to thank Professors Lund and Rosenthal for being here today, making the trip to join us, and I'm sure they're going to provide some stimulating conversation, as will the student group. I want to thank Andrew and his student members of the committee for your leadership in putting this together. I want to thank the faculty advisors and certainly the different organizations for working together to put together today's program on triggering the Second Amendment in terms of related to constitutionality of gun rights and gun control. Although I'm a material scientist and engineering professor, I do watch PBS, and so I actually do watch the Constitution show periodically. And you know, when you watch that, it really is really pretty clear, even to a metallurgist as I am, that the Constitution issues are as relevant today as they were at the creation of the document, and certainly in many cases even more so. Many issues that we deal with and often are topics of conversation and exploration on that program, literally relate to issues around every amendment. You can talk about the Second Amendment today, but you could go down the list in terms of issues that relate to privacy, certainly very important today. Issues that relate to freedom of speech in terms of some of the different activities that we've had going on around the country in recent years related to that. So you could, again, talk for hours about these different issues, and I'm sure we got a great conversation today. As a technologist, one of the interesting aspects that is certainly stimulating and complicating many of these conversations relates to just the use of technology. Something as simple as the internet around privacy issues. And so I'm not sure that's going to come up much today in our conversation, but it's certainly, from my perspective as an engineer and a scientist, something that when I watch that show, for example, and deal with the constitutional issues, the Bill of Rights issues, and how those are interpreted and all the challenges that we face, the technology piece is one I think is going to create the content for many more meetings like this and many more discussions going forward into the future. So thanks everybody for being here today. I know we have a short time frame to work in, and so I'm going to just again welcome everybody and thank you. Bye-bye.
Thank you, Provost Bazelak. Good afternoon, ladies and gentlemen. My name is Kylie Condon, and I'm the Mistress of Ceremonies. Distinguished guests, faculty, students, and friends, the purpose of today's forum is to celebrate the 226th anniversary of our founding charter, the Constitution. It is an honor to welcome Professor Nelson Lund of George Mason University and Professor Lawrence Rosenthal of Chapman University. Professors, the Constitution Day Student Committee sincerely appreciates your taking the time to be here today to discuss the constitutionality of gun rights and regulations and to answer our questions. I would like to introduce our three panelists for today, Philip Hoffert, Krithika Rajkumar, and Elizabeth Vitale, as well as our moderator, Andrew Breland.
Thank you, Ms. Condon. This morning, gunfire broke out in the Washington Navy Yard in Washington, D.C. At least 12 people are dead, and one shooter remains on the loose after gunmen opened fire dressed in military-style uniforms within the naval complex. Throughout the event today, I ask that you keep in mind that the issues we're talking about have real-world consequences, and that no matter what your opinion is on these issues, we can't stand for these violations of our most basic right of security. Ladies and gentlemen, the Second Amendment of the U.S. Constitution reads, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. In 2008, in D.C. v. Heller, the U.S. Supreme Court held that the Second Amendment guaranteed an individual right to bear arms. In 2010, in McDonald v. Chicago, the court applied this right to the entire country. However, the right to bear arms is not absolute. Like the rest of the Bill of Rights, it's subject to reasonable restrictions. Federal and state legislatures have attempted to limit gun rights accordingly. Recent mass shootings in Aurora, Colorado, Tucson, Arizona, and Newtown, Connecticut have led to calls for bans on assault weapons, increased background checks for those purchasing them, and the formation of a commission to study the effects of gun violence in America. A bill in the Senate addressing these points, the Public Safety and Second Amendment Rights Protection Act, failed by 6 votes this April. Other limits on the right to bear arms have met similar fates, including Maryland's requirement that residents show good and substantial reason to own a gun, ruled unconstitutional in March 2012 by Maryland's highest court. Additionally, Illinois' ban on concealed carry weapons was ruled unconstitutional in December by that state's highest court. And just last week, 2 legislators were removed from office after a recall election due to their support of gun regulations. It is clear that the nation continues to question what, if any, laws concerning gun rights are constitutional, and specifically which rights are guaranteed by the Second Amendment. Today, Professors Lund and Rosenthal will examine constitutional guarantees and restrictions. They will respond to questions about recent shootings and legislative pushes for limits on the right to bear arms. These are indeed controversial issues. And out of respect for the speakers, we ask that you please silence all cell phones and remain courteous throughout the program. Following opening statements, each speaker will respond to questions, with 5 minutes allotted per response. Each question will be directed at either Professor Rosenthal or Lund, and the other will have a chance to make a rebuttal for 3 minutes. We will return to the original speaker for a final 2-minute response to every question. Closing statements of 5 minutes will conclude the program. Professor Lund, the floor is yours. You have 10 minutes, and so will Professor Rosenthal.
Until fairly recently, the Second Amendment was considered to be a kind of joke by the courts and by the American legal establishment. As you know, that changed in 2008 in the Heller case when the Supreme Court struck down the handgun ban in the District of Columbia. This was the first time in history that any federal court had declared any law unconstitutional under the Second Amendment. Justice Scalia wrote the opinion in Heller, and it has many, many serious problems. I won't even be able to scratch the surface of the problems in Justice Scalia's opinion. But he did reach 2 important conclusions, both of which are correct, about the original meaning of the Second Amendment. First, the right to keep and bear arms is a private right of individual citizens, not a right of the states to organize the National Guard or state militias. Second, the purpose of the Second Amendment is to protect the natural or inherent right of self-defense, including the right to defend yourself against criminals. Unfortunately, this does not get you very far in evaluating the constitutionality of specific gun control regulations. Why? Because the historical record contains virtually no discussion about the scope of the Second Amendment right. Very little discussion, virtually none, about the scope of the right to keep and bear arms. And that's what you need to know in order to decide specific questions about specific regulations. Now, that problem becomes quite clear in the Heller opinion itself when Scalia addresses the question of whether the handgun ban violates the Second Amendment. And he decides, he and the majority of the court decided that it did, but why? The only reason he gives is that handguns are a popular weapon of self-defense today. No discussion of any history, nothing about the original meaning of the Second Amendment, just a kind of statement that, well, they're really popular today, and therefore it's unconstitutional to ban them. The rest of the opinion consists, in my view, of an incoherent set of comments that provide very little guidance about how to analyze other gun control regulations. Okay, we've been told by the Supreme Court a handgun ban is unconstitutional. What about all kinds of other things? Very little guidance is provided by the court's opinion. Surprisingly, perhaps, the federal circuit courts, that's the Court of Appeals, have largely coalesced around an analytical framework that can be roughly summarized as follows. First, some regulations, primarily those that are long-standing, are presumed not to infringe the right protected by the Second Amendment. Second, regulations that severely restrict the core right of self-defense are subject to what's called strict scrutiny. Now, that's a legal test requiring the government to prove that it is using the narrowest possible means to accomplish a compelling government interest, and very few laws of any kind will pass that test. Third, regulations that do not severely restrict the core right are subject to what's called intermediate scrutiny. Now, that's a more relaxed legal test that requires the government to prove that the law is substantially related to an important governmental objective. This kind of tiers of scrutiny approach is used in other areas of constitutional law, so it's not surprising that the lower courts would try to adapt it to this area. But it was conspicuously not adopted in the Heller opinion. And that problem generated an interesting debate in the Federal Court of Appeals for the District of Columbia Circuit, which I'm going to just very briefly describe. After losing the Heller case, the DC government adopted a new gun control law. And in a case called Heller 2, the named plaintiff in the earlier case, along with several other individuals, challenged several of its provisions. And I'm just going to focus on two of them because they've been subject to a lot of commentary recently. First, a prohibition on so-called semi-automatic assault rifles, and second, a ban on any magazine with a capacity of more than 10 rounds. The Heller 2 majority concluded that it's reasonably certain that the bans do not substantially burden the Second Amendment right, and then following this tiers of scrutiny approach, the court then applied intermediate scrutiny and upheld both regulations. In dissent, Judge Brett Kavanaugh argued that the majority's approach to the case was based on a complete misinterpretation of Heller. In his view, the Supreme Court has rejected the tiers of scrutiny approach. Instead, according to him, Heller teaches that courts are to assess gun regulations by looking to history and tradition and by drawing analogies from these sources when dealing with modern weapons and new circumstances. Anything else, he maintains, involves judicial interest balancing, which Heller expressly condemned. Now, in my view, Justice Scalia's opinion in Heller is so confusing that there's no way to tell for sure which approach is the right interpretation of the case. But I think it's pretty clear that the majority's analytical approach is workable and Judge Kavanaugh's is not. And judging from the sign back there, it doesn't look as though I'm going to have time to get into too much detail about Judge Kavanaugh's position. So I'll just make this conclusory remark that I think I can show that it's not workable and turn to the majority opinion. The basic problem with Kavanaugh's approach is that the history and tradition aspects of Scalia's Heller opinion are kind of, I don't want to say dishonest, but I do want to say very misleading about what they can and cannot do. So I think the majority's analytical approach in Heller 2 is something like it is the only workable approach. But that does not mean that I think the majority correctly decided the case, and that's what I want to focus a couple minutes on. The challenged regulations that I mentioned were manifestly meant to suppress the legitimate exercise of constitutional rights, and the majority was far too deferential to the government in reviewing them. Let me start with the ban on certain semi-automatic weapons. First, the banned rifles are defined primarily in terms of cosmetic features, And they're indistinguishable functionally from other semi-automatic rifles that are not banned. The regulation is therefore arbitrary and without any real relation to public safety, and it fails the majority's own intermediate scrutiny test. There's more I could say about that, but I'm going to suppress it because of lack of time. What about the ban on high-capacity magazines? The majority offered two justifications. First, it said that such magazines give an advantage to mass shooters. Maybe so. But how could the district's regulation possibly reduce that problem? Large capacity magazines are freely available by mail order and at stores in nearby Virginia. The court seems to be assuming that criminals bent on mass shootings will refrain from obtaining such magazines out of respect for DC's regulation. Now, rather than thoughtlessly accept this really preposterous assumption, I think the court might well have taken judicial notice of the opposite. The majority also said that large capacity magazines can tempt legitimate self-defense shooters to fire more rounds than necessary. Once again, maybe so, but that shows at most that banning such magazines could conceivably have some good effects on some occasions. But exactly the same thing could be said of DC's original and unconstitutional ban on all handguns, which illustrates why the argument has to be fatally flawed. Just think about an analogous case under the First Amendment. Banning medical books containing photos of corpses or cadavers might save some children from psychological trauma if they came across such books. That would be a good thing too. But nobody would consider such a book ban constitutional. Assuming that intermediate scrutiny is appropriate, the government is required at a minimum to show a substantial relation between the regulation and public safety. The Heller majority cited no evidence showing that the magazine ban would save any significant number of lives or any lives at all, nor did it even consider the possibility that innocent civilians might lose their lives because they ran out of ammunition while trying to defend themselves. Now, where does that leave us? I think it leaves us with what I regard as almost inevitable conclusion that the courts are going to apply some kind of means-end scrutiny, whether they call it tiers of scrutiny or not, and that what's really going to determine the future of Second Amendment rights is how valuable judges think the Second Amendment is. Judges think the First Amendment rights are very valuable, and we have a long and complex tradition of rigorous judicial scrutiny of laws that violate the right of free speech. There are some judges willing to use similar rigor in analyzing Second Amendment cases. Unfortunately, there aren't enough of such judges yet, but there are some. They don't seem to be on the DC circuit, however. Thank you.
Professor Rosenthal.
Thank you. I want to start with Antonin Scalia, pretty much the place Professor Lund started. Justice Scalia, as the law students in the room knows, is the great foe of common law methods for interpreting the Constitution, because that, he says, gives rise to this odious thing called a living Constitution, made by judges, not by the framers of the Constitution. He tells us that the Constitution, like any other legal text, has to be written in light of its meaning at the time of adoption, the original meaning of the words. And in District of Columbia versus Heller, the case establishing that the Second Amendment grants an individual right to keep and bear arms, Justice Scalia was able to utilize that methodology. Through his assessment of the historical evidence, Justice Scalia gives us what he determines or concludes is the original meaning of the Second Amendment. In short, he tells us that the right of the people in the operative clause of the Second Amendment means an individual right. The word keep means to possess firearms. The right to bear means the right to carry in case of confrontation. And arms, what are they? They're any firearm in common civilian use. So, if all you're doing is using the original meaning of the operative clause, we have an enormously robust right. Every individual has the right not only to possess, but to carry in case of confrontation any firearm in common civilian use. Yet, as Professor Lund suggests, a lot of puzzles are left by the Heller opinion, and I want to focus on a couple of them right now. The first puzzle is the dicta that Justice Scalia gives us on what he talks about as presumptively lawful firearms regulation. And he gives us examples. He says in the opinion, these aren't exhaustive, but here are some examples. And he says prohibitions on the possession of firearms by convicted felons, the mentally ill, are examples, as are prohibitions on carrying concealed firearms or carrying firearms in sensitive places. Now, I say that's a puzzle because if the operative clause, in particular the original meaning of the operative clause, is what we need to worry about, how can you prohibit firearms under these circumstances? Professor Lund uses the analogy of the First Amendment. Well, you can't prohibit convicted felons from exercising the right of free speech, or perhaps more pertinently, since the Supreme Court's decision in Neer versus Minnesota, the fact that you abused your free speech rights by publishing a defamatory newspaper doesn't mean that publication can be enjoined. There's no death penalty for the First Amendment, but how can a felony conviction be the death penalty for Second Amendment rights? Same thing with the mentally ill and these other prohibitions. Now, you could say it's only dicta, it's not the precise holding of the court. Justice Scalia does say, well, we'll deal with these things in subsequent cases, so maybe that's not as troublesome as it first appears. But what about the holding? If there's an individual right to keep and carry any firearm in common civilian use, then this is a slam dunk case. You can't ban handguns, you can't ban anything as long as it's in common use. But that's not what Justice Scalia tells us, as Professor Lund indicates. Instead, he throws a ton of words at us that amount to saying, well, the Second Amendment is about a core right of lawful armed defense, especially in the home. And this law strikes at the heart of that core right. Now, where's that coming from, this notion of a core right and the extent to which it's burdened by a challenge regulation? Not from the original meaning of the operative clause. What's going on? And then we look at what the lower courts have done since Heller, and as Professor Lund indicates, the original meaning of the operative clause has played almost no role in the litigation in the lower courts. A couple weeks ago at the meeting of the American Political Science Association, I was on a panel with somebody from the NRA, which called the pattern of decisions in the lower courts since Heller a campaign of massive resistance. His words, not mine. But it's right. Instead of focusing on what Justice Scalia tells us is the original meaning of the operative clause, the courts tend to use a kind of means-ends scrutiny in light of the burden imposed by the challenge regulation. Does it have sufficient offsetting benefits? Where does that come from? Certainly not the original meaning of the operative clause. This is a great puzzle. Are we seeing a campaign of massive resistance, or is something else going on? Well, if we then look at history, as Justice Scalia says we should, we find another puzzle, because historically, we have a long tradition in this country of regulating, even imposing prohibitions when it comes to the right to possess and carry in case of confrontation. The English Bill of Rights, which Justice Scalia tells us was the origin of our Second Amendment, it provided that Protestants could keep and bear arms as provided by law, suitable for their condition. So Catholics, no, you're out of luck. Women, I don't even want to begin with women. That wasn't even on the radar screen. And even then, Parliament could regulate, and only suitable, you could only have suitable arms. So Parliament could deal with the lower classes in the framing era. The right to bear arms was denied for suspect groups like, again, women, freed blacks, not to mention, of course, even slaves weren't on the radar screen. Some states denied the right to people who wouldn't swear loyalty oaths, and some states denied the right to Catholics. People had to produce their firearms under the militia laws at periodic musters where they'd be registered and inspected. What's going on there if you have this unfettered right? In the 19th century, more laws emerge. In the 1820s, the southern states start passing laws prohibiting the carrying of concealed weapons. In the north, more sweeping prohibitions on carrying in public places are enacted. After the Civil War, the same Congress that ratified the 14th Amendment passed a law prohibiting the arming of southern militias because these incipient Ku Klux Klan-type groups were on a campaign of terror. Frontier towns often prohibited the carrying of firearms to stem epidemics of violence. And in the 20th century, of course, we see more laws, like the laws prohibiting possession by convicted felons or people to be adjudicated mentally ill. So what's happening? Well, my suggestion is that actually the problem is not that we're all ignoring the operative clause, but that it's too easy to overlook the preamble, a well-regulated militia. The only provision in the Bill of Rights that contemplates regulation is the Second Amendment. Now, Heller tells us something else awfully interesting about the original meaning of the Second Amendment. He tells us the original meaning of that word militia was not being in some sort of formal paramilitary organization. The original meaning was that the militia was everybody qualified to own a firearm. You were automatically in the militia. You didn't sign up. That group was well regulated. Now, if we take that seriously, then the Second Amendment contains textual acknowledgement of both firearms rights and regulatory authority in a way you see nowhere else in the Bill of Rights. And this is why courts, I think, have been looking to the tools they use in other areas of constitutional law where the Constitution recognizes both an individual right and legitimate regulatory power. Why what seems to be emerging, even implicit in Heller itself, is some version of an undue burden test, evaluating the extent to which challenge regulation burdens Second Amendment rights, and then assessing its justification. And that regulatory power is so broad that classes of individuals thought to be high risk, whether it was people who wouldn't sign loyalty oaths in the framing era or convicted felons today, can be denied those rights because we have this unusual textual recognition of regulatory authority. Now, I think Professor Lund is quite right. It all matters how you administer this test. And so I want to conclude with one of his examples about detachable cartridge and large capacity cartridges. And Professor Lund tells us, well, why would you make those illegal? Because criminals can still get their hands on them. Some of you laugh. Well, I have another thing that's funny. Why ban heroin? Criminals can get their hands on heroin. Nobody thinks that by making it illegal to possess heroin, we've wiped out heroin. In fact, most of the criminal law involves prohibitions that criminals can find their way around if they're determined enough to do so. So why do we ban heroin? And economists can tell us because when you make something